clicks. Access பண்ணாலே வந்து next moment நம்மளுடைய இது வந்து track ஆகிடும், IP address track ஆகிடும். But there are a lot of child pornography that is doing the rounds in the dark web. Even that is brought under the provisions of 9. And another interesting thing here, 103. 103 is nothing but 302. But 103 is now stands bifurcated into 103.1 and 103.2. 103.1, a simpliciter, it is the erstwhile, what is going to be the erstwhile 302. Whoever commits murder shall be punished with a death or an imprisonment for life, also shall be liable to fine. That's what we should raise. Now, 103.2 is a new addition. When a group of 5 or more persons acting in concert commits murder on the ground of race, caste, community, sex, place of birth, language, personal belief, or any other similar grounds, each member of such group shall be punished with death, with imprisonment for life, and shall also be liable to fine. What is something interesting about it? Not very usual. Unlawful assembly. 147, 148, 149. Why this incorporation? Because this is something interesting. Mob lynching is our concept on the basis of religion, discrimination on the basis of religion, caste, and whatever that has been highlighted in this. In the mob lynching, a specific address பண்ணுறதுக்காக மட்டுமே இந்த ஒரு sub-enactment of section 103 has been incorporated. Now the question would be, இதெல்லாம் ஏற்கனவே இருக்கிறது என்ன பெரிய விஷயம். Interestingly பார்த்தீங்கன்னா, a murder is punishable either with death or life. That is what is given. Now, the erstwhile 300, which is now 101, gives exception to murders. Suppose, for example, 5 members, because 103.2 says 5 or more. 5 members for a tea shop there. திடீர்னு ஒருத்தனை பார்க்குறாங்க, அடிக்கிறாங்க. ஒரு சண்டே they try to pick up a quarrel with this person. அடிக்கிறாங்க. அடிச்சுட்டு they take a defense. ஒன்றும் இல்லைங்க, டீ குடிச்சுருந்தா அவங்க கெட்டாவத்தில் இருக்குன்னா நாங்கள் திருப்பி இருக்கோம், 2 பேரும் அடிச்சுக்கிட்டோம். ஸோ upon a sudden, first exception 4க்கு எடுத்துகிட்டு போனாங்கன்னா, upon a sudden quarrel, in a heat of bit of rage, in a heat of passion, without taking undue advantage, இந்த offense நடந்துச்சுன்னு ஒரு எக்ஸெப்ஷன் எடுக்கணும்னு அவங்க நினைச்சாங்கன்னா 103.2 would be a stumbling block. ஏன்னா the prosecution has to put forth a case that this occurrence is not as projected by the defense, or அவங்க தான் primary, the onus is always on the prosecution to say that this is the case of the prosecution. So prosecution has to say this is a murder based, there was a discrimination, this person belongs to a particular community or particular caste, creed, sex, whatever that's been defined, it will not be true. அந்த காரணத்துக்காக தான் அந்த சண்டே எடுத்து சண்டையை போட்டு அடிச்சு உழைச்சாங்க. இட் இஸ் நத்திங் பட் மாப் லிஞ்சிங் ப்ராசிக்யூஷன் எஸ்டாப்ளிஷ் பண்ணிட்டாங்க. தென் தி எக்ஸெப்ஷன் தட் இஸ் அவைலபிள் டு தி டிஃபென்ஸ் will get it. So only to curb the rising incidence of mob lynching, this particular enactment is brought forth, and it's a welcome one, definitely, because the kind of a hatred that is there in the society needs to be addressed, and the number of murders that is happening on account of hatred amongst human beings needs to be addressed, and this would give the prosecution an upper hand that it should be punished when a person does an act or a group does an act on the basis of, on a ground of discrimination, on the basis of caste, religion, and other etc. So therefore 103.2 is an interesting one. The other one would be section 104, which is a parliamentary section 303, which was repealed by the Honorable, which is very ultra virus by the Honorable Supreme Court, because the only punishment that was provided in 303 was death. So there was a danger when a person is found guilty under section 303. The only option that was available to the executive would be hang him or kill him by death. So that was the point of consideration before the Honorable Supreme Court, and he said when you don't have an alternative sentence, it ultra vires the Constitution, therefore they held it is ultra vires and that repeated. Now interestingly, that 303 is again enacted. Now 404 says punishment for murder of a life convict. Whoever being under the sentence of imprisonment for life commits murder shall be punished with death or with imprisonment for life, which shall mean for the remainder of the person's natural life. And these last few words is what makes it different from that of 104, 103, what? So simple can be life or death. Life convict, life or death. These few words which shall mean that the remainder of that person's natural life. So remission, commutation, everyone. So instead of death alone, this enactment says death with imprisonment for life, and which shall mean that the remainder of the person's natural life. So the aggravated punishment is now brought forth by way of 104. Now coming to another interesting new enactments would be section 111, 112 and 113. 111 again, all the three provisions are now need of the hour. Organized crime, petty organized crime and terrorist act, which is 113, which is terrorist act. So the days are gone, right, where people committed offence on an individual level, or one or two people committing an offence. Now things have become organized. It is a parliamentary area to Maharashtra organized crime. So organized crime is defined. In the structuring of this provisions, 112, 111, 112 and 113, more interesting because it is self-contained, it's got everything, all the ingredients and what, all the exceptions, everything is given there. I'll read 111, organized crime. Any continuing unlawful activity, including kidnapping, robbery, vehicle theft, extortion, land grabbing, contract killing, economic offence, cyber crimes, trafficking of persons, drugs, weapons or illicit goods or services, human trafficking for prostitution or ransom by any person or a group of persons acting in concert, singly or jointly, either as a member of an organized crime syndicate or on behalf of such syndicate, by use of violence, threat of violence, intimidation, coercion, or by any other unlawful means to obtain direct or indirect material benefit, including financial benefit, shall constitute an organized crime. It's very interesting because each and every word that may lead to interpretations has been defined. So what is an organized crime syndicate? Explanation 1 says, subsection 1. Organized crime syndicate means a group of 2 or more persons who, acting either singly or jointly as a syndicate or a gang, indulge in any continuing unlawful activity. 2. What is continuing unlawful activity? Means an activity prohibited by law, which is cognizable offence, punishable with imprisonment for 3 years or more, undertaken by any person either singly or jointly as a member of an unorganized crime syndicate or on behalf of the syndicate, in respect of which more than one charge sheet has been filed before the competent court with the preceding 10 years, and the court has taken cognizance of such offence, including economic offence. What is an economic offence? It says subsection 3. Economic offence includes criminal breach of trust, forgery, counterfeiting, currency notes, bank notes, government stamps, hawala transactions, that has been italicized, bringing forth the seriousness of hawala transaction. Mass marketing fraud, running any scheme to defraud several persons or doing any act in any manner with a view to defraud any bank or financial institution or any other institution or organization for obtaining monetary benefits in labor. So number let's confine ourselves to the first portion of this. இது எல்லாமே வந்து இண்டிவிஜுவலா வந்து these offences are defined. Kidnapping is defined, robbery is defined, vehicle theft is defined, extortion is defined, so on. எல்லாமே defined ஆகுது except cyber crimes ஆகல. Cyber crimes வந்து we have to resort to the Information Technology Act. Drugs வந்து you have to go back to ADPS. எல்லாமே வருது. Now, a syndicate, organized crime syndicate, 2 or more persons. So 1, 2 or more மரபுகளை வந்து. So now there are entities which are so connected to perform one part of a continuing unlawful act. Say for example, somebody robs a vehicle. It is a robbery simpliciter. Now, how does a person is brought into the purview of section 111? Now, interestingly, when a person robs a car, the car is sold in the market. So there is a proceeds of crime. That proceeds of crime can be used into some other offences which will form part of the crime. That money could be it can be used to purchase drugs, or it can be used to purchase weapons, human trafficking, so on and so forth. Now, these individual acts, if they are so connected, they form a syndicate. So, boss India work somebody would be robbing a car, we do not know. அவன் காரை திருடிட்டு வித்துட்டு கேஷை அவன் எடுத்துப்பான், அவனுக்கு ஸ்பான்சர் பண்றதோ பார்ட் ஆஃப் த கேஷ் அங்கே போயிடும். அந்த கேஷ் இன்னொரு இடத்துல போயிட்டு ட்ரக்கில் மாஸ் ப்ரொடக்ஷன் ப்ரொக்யூர் பண்ணி அது வந்து ட்ரக் டீலிங்கில் போயிட்டு இருக்கும். ஸோ தேர் இஸ் ஒன் ஆக்ட் ஸோ இன்டர்கனெக்டட் வித் அதர் ஆக்ட் 1, 2, 3, 4. அதுக்கு தான் அவங்க டிஃபைன் பண்ணுறது கண்டினியூங் லாஃபுல் ஆக்டிவிட்டி. அது என்ன அழகாக a member of an organized crime syndicate or on behalf of the syndicate in respect of which more than one charge sheets have been filed before the competent court. So எங்கேயாவது ஒரு இடத்துல ஒரு காம்படென்ட் கோர்ட்ல வந்து ஒரு சார்ஜ் ஷீட் ஃபைல் பண்ணிட்டாங்க 10 வருஷத்துல, ப்ரீவியஸ் 10 years. அந்த சார்ஜ் ஷீட்டோட கனெக்ட் ஆகுது offences. So this forms a syndicate. When this forms a syndicate, that would be brought under the organized crime. Now, இதுக்கு என்ன punishment? 111(2) speaks about the punishment. If such offence has resulted in the death of a person, be punished with death or imprisonment shall be liable to fine which shall not be less than 10 lakhs. Now, the 10 lakhs now is being quantified, and also shall liable to fine under the not less than 10 lakhs because 111 also involves economic offences. It involves economic offences. So, as it snowballs, ஒரு சின்ன டெப்டா நம்ம பார்க்கறது வந்து ஒரு எண்ட் ப்ராடக்ட் எங்க இருக்குன்னா இட் வில் பி ஒரு ட்ரக் டீலிங்ல போயிட்டு இதுக்கு போயிட்டு ஹியூமன் டிராஃபிக்கிங் போயிட்டு தட் ஒன் பர்சன் வுட் பி அமாசிங் வெல் அவங்க கிட்ட வரும்போது ஸ்னோபால் எஃபெக்ட் ஆகி he would be sitting on a booty ஒரு 100 கோடி சாம்ராஜ்யத்துக்கு மேல ஒரு உட்கார்ந்துட்டு. So he will be the kingpin of the syndicate. So therefore, to bring them all under one, so if the prosecution is able to establish A being the boss, till Z, இதெல்லாம் connecting points சொன்னாங்கன்னா A to Z அத்தனை பேரையும் can be brought under one charge sheet and can be prosecuted as an organized crime எடுத்து வந்து punishment சொல்றாங்க. If somewhere ஒரு கொலை நடக்குது, அந்த கொலையை இன்வெஸ்டிகேட் பண்ணும்போது they stumble upon something, இது இந்த மாதிரி தான் நடந்துட்டு போயிருக்கு, இதுக்காக தான் நடக்குதுன்னு போகும்போது அந்த மர்டருடைய இன்வெஸ்டிகேஷன் will take a different turn altogether. So if it is a murder simpliciter, we'll fall back to 103. Suppose ஒரு இடத்துல சுட்டுறாங்க, எதனால சுடுறாங்கன்னு பார்க்குறாங்க, இவன் வந்து இன்ஃபார்மர், he is informer who is trying to inform the police regarding a drug deal. சரி, அங்கே இன்ஃபார்மரோட ட்ரக் டீலர் லிங்க் பண்ணுறாங்க, ட்ரக் டீலரோட யாராவது அஃபெண்டர்ஸ் பார்க்குறாங்க, இந்த அஃபெண்டர்ஸோட லிங்க் பண்ணுறாங்க, சுற்றி வரும்போது the larger conspiracy is as elsewhere. So bring all of them under one charge sheet by invoking section 111. So the primary ingredient would be that it should be an organized one, and the roles played by each and every one, different roles, would be connected, so interconnected, to bring all of them into one offense. So connect பண்ணிட்டு. Now the interesting would be, next would be, the next section is 2B. In any other case shall be punished with imprisonment for a term which shall not be less than 5 years, and which may extend to the imprisonment for life, shall also be liable to fine which shall be not less than 5 lakh rupees. So there's a minimum punishment that is prescribed. So these are the small nuances that makes this enactment in totality slightly different from what it used to be. 3, subsection 3, whoever abets, attempts, conspires, knowingly facilitates the commission of an organized crime or otherwise engages in any act preparatory to an organized crime shall be punished with an imprisonment for a term which shall not be less than 5 years, and which may extend to imprisonment for life, and also be liable to fine which shall not be also less than 5 years. So again, these are extension. As I said, 111, 112 and 113 is very self-contained, and it has got all the definitions that need not be interpreted. So a person abets, attempts, conspires, knowingly facilitates. So as I said, who sits on top is never going to come to the ground level to commit an offense. Whoever abets. நீ போய் அவன் செஞ்சுட்டு வான்னு சொன்னான்னா மேலே உட்காந்துருப்பான், அவனோட சொல்ல மாட்டான், என்னடா பிரச்சனை போய் பார்க்கலாம். A dictates to B, B dictates to C, C dictates to D, D commits the offense. A is also punishable under by virtue of section 111 clause 3 because he abets. Conspiracy and abetment, though they are two different things, they go side by side. And or knowingly facilitates. Again, that knowingly would impute intention. Whoever knowingly facilitates, suppose somebody is charged with 111 subsection 3 for purchasing a knife. Now, it is for the prosecution to prove that he had the intention and the knowledge that he is purchasing that knife to commit an offense which is punishable, murder or attempt to murder or whatever. So it is a little safeguard that is provided. The prosecution must, because knowingly facilitates enactmently, the burden lies on the prosecution. It is not the reverse burden. The burden lies on the prosecution to say knowingly facilitates. Again, the seriousness of the act is now made clear by giving a minimum punishment. And 4, any person who is a member of an organized crime syndicate shall be punished with imprisonment for a term which shall not less than be 5 years. Again, interesting. Any person. This is a contentious provision. As I said, 111.3, if it is a provision which can be made good use of, 104 is a dangerous provision because any person who is a member, there need not be an overt act. Subsection 3 says, abetment, attempts, conspires, knowingly facilitates, and knowledge of the intention of the 4, any person who is a member of an organization. Suppose if I had to be a driver of A, the boss, the kingpin. Out of my economic compulsions, I'll be a driver. I'll become a driver. I'm working for him. I do not indulge myself in any other overt act which is attributable to A or A to Z. Whether I can be brought under subsection 4, it is subject to interpretation by the Constitution. Now a person can say, எனக்கு பண கஷ்டத்துக்காக என் குடும்ப வறுமையின் சூழ்நிலையால நான் ஒரு டிரைவராக போவேன். அப்படி நான் போயிட்டு அவனுக்கு வண்டி ஓட்டிட்டு இருந்தேன்னா I will also be made an accused under subsection 4. If நான் அந்த ஆஃபீஸில் வந்து ஒரு கணக்காளர் அக்கௌண்ட் I'll be day in and day out calculating and I'll be counting the blood money. I can also be accused under 111(4). Now, we do not know on whom the burden is to prove the innocence. Whether their innocence is already there prescribed in the Samhita, or I'll have to prove my innocence in the and do an explanation. That is a contentious part. Now, another interesting thing. 5. Whoever intentionally harbors or conceals any person who has committed the offence of an organized crime shall be punished with an exception for a term which shall not be less than 3 years, which may extend to life. So the gravity of the punishment is reduced, and there's a minimum fine of 5 lakhs. Interestingly, the spouse is exempted, provided the proviso says that is the subsection shall not to any case in which the harbor or concealment is by a spouse of the other. Fair enough. அப்பா அம்மா வந்து ஹார்பர் பண்ணாங்கன்னா வெதர் தட் குட் பி அஃபென்சிவ் கேட்டு. ஸோ அப்படின்னு வரும்போது தேர் இஸ் நோ ஆன்சர். சப்போஸ் மதர் பாடமானே வீட்டில் வந்து சாப்பிட்டு போடான்னு சொன்னாங்கன்னா whether that would amount to harboring is not covered under the provision. But whoever intentionally, interesting over there must be an intention to harbor or conceal. So the general exception of wife on the exception, spouse accept பண்றாங்க. wife பண்றது தப்பு, கணவனோட இருந்தாங்கன்னா தப்பு கிடையாது, மனைவி இருந்தாங்கன்னா மனைவி இருந்தா தப்பு கிடையாது. That's not. What about siblings? What about parents? இதை வந்து இது ப்ரொவிஷன் டச் பண்ணுறாங்க. மோர் தென் அ வைஃப், ஃபாதர் அண்ட் மதர் would be more than willing to. என் பையன் தப்பே பண்ணிட மாட்டாங்க. That would be the primary mindset. என் பையன் தப்பே பண்ணிட மாட்டான்னு ஒரு தாயின் தகப்பன்னு நினைக்கும் போது அவங்க வந்து தன்னுடைய மகனை வீட்டில் வந்து அடைக்கலம் கொடுக்கறது whether that would amount to harbors or conceal. Though there may be a strong case against it. Now the question of intention. So again, it is prone to interpretation by the Constitution. Now another interesting one will be section 6. Whoever possesses any property derived or obtained from the commission of an organized crime, or proceeds of any organized crime, or which has been acquired through an organized crime, shall be punished with imprisonment for a term which shall not be less than 3 years, but may extend to imprisonment for life, shall also be liable to fine, which shall not be less than 2 lakh rupees. Now, importing certain ingredients from the PMLA. Possession of a property derived or obtained from the commission of offence. Now, PMLA acts on a predicate offence. Now here, the predicate offence and the possession of the proceeds of crime are brought together under one provision, which is 111(6). Suppose I buy a car out of a crime that has been committed, which could be a drug one or a trafficking or whatever. That mere possession of that vehicle will make me liable to be prosecuted under section 111 subclause 6. So, even offences which are not scheduled offences under the PMLA can be brought and tried or prosecuted under section 111(6). 111(7). If any person on behalf of a member of an organized crime syndicate is or at the time, any time has been in possession of a movable, immovable property which is he cannot satisfactorily account for, he shall be punished with imprisonment for a term which shall not be less than 3 years, which may extend to 10 years, and also So now the question would be possession of movable or immovable property. Now the law provides the person who is found in possession of a movable or immovable property out of the resources from an organized crime. If he cannot satisfactorily explain, suppose money trailer suppose that person says, I sold my property to him for which I had taken that as a safe transportation. For example, since I owed him money, he did not repay the money, now he gave the car to me. Whether he should be also criminalized. That is why the legislature has thought it fit that he cannot satisfactorily account for. If that satisfactorily or subjective satisfaction is infused into the investigative agency, he may be exonerated. Now again, the ball is left on the courts of police. That is a dangerous one. Either is one such thing, because the police are given, because if you see the Nagarik Suraksha Sanhita, police are given powers, excessive powers to an extent. Sila Vishayangala. So Sila Vishayangala there are curves. But either my Sila Vishayangala, it is our skills that's going to safeguard the interests of the innocents. Now interesting, another one is 106. So 106 also there was a confusion whether it's going to be put to use or it's going to be kept in abeyance. The recent notification says that it will be deployed. 106 is 304A, which is the most common offense. எல்லாருமே 304A கேஸ் நம்ம நடத்திருப்போம். நான் நடத்திருக்கேன். Causing death by negligence. இதுல ரெண்டு லிம்பு இருக்கு. Now, negligence exhibited by a medical professional is now incorporated into the Nyaya Samhita. Now, putting the good job of the medical practitioners into some kind of a error. எந்த ஒரு டாக்டரும் யோசிப்பாங்க ஒரு நிமிஷம் நம்ம இந்த enactment உள்ள வந்துட்டோம். Interestingly, I'll read the provision. Causing death by negligence. Whoever causes death by any person by doing any rash or negligent act not amounting to culpable homicide shall be punished with an imprisonment for either description for a term which may extend to 5 years, shall also be liable to fine if such act is done by a registered medical practitioner while performing the medical procedure, which shall be punished with an imprisonment for either term, the description for a term which may extend to 2 years and shall also be liable to fine. So two limbs. One, rash and negligent act. I'll end the question. The unfortunate enactment would be enhancing the punishment. See, now that it is held, it is rash and negligent. In another word, it is an accident. Accident caused by national negligence. 5 years is the punishment. Before it used to be 2 years. Now it's 5 years. The seriousness is way a little more in this enactment. 2, bringing in the medical practitioners while performing medical procedure. Jacob Matthews case D'Souza case, Martin D'Souza case in the case we made, and thereafter consistent view taken by the Honorable Supreme Court is that it is not a mere negligence that will attract an offence under 304A. It is something more, and they have added the word gross negligence. And the gross என்றது consistent சொல்லிட்டு இருக்காங்க. That provides the medical practitioners the safeguard that they require while performing. It is a judgmental. Suppose something goes wrong, it is a judgmental error. நம்மளே day in and day out we keep making mistakes. Client பயங்கரமா pressure பண்ணாங்கன்னா we file a petition, though we know the outcome of it. So in such cases, we cannot be blamed for the simple reason we are acting in good faith as lawyers only to protect the interests of the client. We do advise that, don't do this now. Number, they cannot blame us because we are sitting on a judgment as what is good to our client. That's medical practitioner. At least we can all give a senior solution. After all, we are criminal defend. That is one thing. Interestingly, NTs are never ask the accused whether he is committed the offence or not. You should not frame an opinion on the case. Once you take up the brief, it is your brief. Don't bother the person has committed the offence. I had a lovely experience of interacting with the NTV sir. That's a different thing. Adanala, we are sitting on a judgment. Likewise, doctors while performing a procedure, they don't expect or they don't play around with it because we have seen, because that split minutes, the seconds down, either in the artery or decide there cannot be rashness because the focus is going to be there in the court. That is why the case on the Supreme Court left call surgery, right call that is grossness. Left call surgery, left call minor mistake, complications. You cannot blame him because it is a judgmental error. That's all. We make use of our skills, and that skill is gone wrong, then you cannot punish a person for rash and negligent. So the gross negligence in Ravati of this Nyaya Sangita failed to import into the act. And another interesting thing, subsection 2. Either one is dangerous proposition. Whoever causes death of any person by rash and negligent driving of a vehicle not amounting to culpable homicide and escapes without reporting it to a police officer or a magistrate soon after the incident shall be punished with an imprisonment for either description of a term which may extend to 10 years and shall also be liable to fine. Now this covers the hit and run cases. Hit and run cases the onus is on the person who has committed the offence to report it to the nearest police station or the magistrate soon after the incident. Now the soon after it is a relative case. Soon after the incident it could be half an hour, which can run to several hours. I said the police can and the leeway. See, while making a legislation, we are supposed to see the dark side of the one of the three parties to this event, the police. Suppose on a highway or night time or accident we are seeing it day in and day out. Vehicle. So, an accident is an accident. When I flee that place, endangering something to my life and my property, my vehicle, fair enough, I am expected to go report. Suppose, I travel for 3 kilometers, 3 travel, Now the law provides you can lodge a complaint before any police station, even on an email you can lodge a complaint, because Nyaya Sangita says you can do that. And it should be transmitted to the jurisdictional police station through mail or whatever sources. So a police officer or station officer cannot say no while receiving a complaint. 99% enforce So now whether the police can say you have not informed the nearest police station soon after the incident, and whether he can bring me under the provisions of section 106 of clause 2, the answer would be an affirmative yes. Panala. So, what is liable to be punished under section 106 of clause 1 now is upgraded to 106 sub clause 2, 10 years. In order to avoid being prosecuted under section 106 of clause 2, there is going to be a bargain by the police. What is the safeguard? There is absolutely no safeguard. Though the safeguard is supposedly given under the provision, which can say that you can always tell the magistrate. After 6 o'clock, I don't think any normal person or any person is not accessible to the magistrate. So, suppose the magistrate is surrender, it will take at least 12 hours. That 12 hours would definitely come within the ambit of failure to report soon after the incident. So, I have invited myself a danger of being prosecuted under section 106 subclause 2. So 106 in a way is they have demonized the provision of section 304A. This would be my understanding. Now, interestingly, section organized crime shift 112. 112 is petty organized crime. Petty organized crime is interesting shape. 112. Whoever being a member of a group or a gang either singly jointly commits an act of theft, snatching, cheating, unauthorized selling of tickets, unauthorized betting or gambling, selling public examination question papers, or any other similar criminal act is said to commit petty organized. Explanation. For the purpose of subsection theft includes strict theft, theft from vehicle, dwelling house or business premises, cargo theft, pickpocketing, theft to skimming, car skimming, shoplifting, theft of automated machines. Now, petty organized crime. It may not lead to death, but the snatching under வார்த்தை because snatching is an offense, independent offense under section 302. We all know the seriousness of snatching. நம்ம நிறைய சிசிடிவி பார்க்குறோம். கர்ப்பிணி பெண்களை செயினை ஸ்நாச் பண்ணி அப்படியே கீழே வந்து டிவியும் பார்க்கும்போது வயசானவங்க பதாமல் நடந்து போயிட்டு இருப்பாங்க. வந்து செயினை இழுத்துட்டு போவாங்க, அப்படியே தலை மல்லாக்க விடுவாங்க, எடுப்பாங்க, ஃபேஸ் டவுன் விடுவாங்க. These are now made an independent offense under section 304. If it is organized, because now helmets are made compulsory. So the general attitude or general modus of the criminals will be make use of the law cards. So helmet போட்டு ஒரு கலர் பைக்கில் ஒருத்தன் செயின் அடிச்சான்னா, even if you catch him after maybe a kilometers run, he will not be able to recover the chain. And the chain 10 இடத்துல கை மாறும். That's what Sodharan used to say. In the case Sathyan used to get right, because we learned so many things about trial and justice. சொல்லும்போது சின்னதாக காசு குட்டி கதை சொல்லிடுறேன். அந்த மோகன கிருஷ்ணன் வந்து நான் சில டைமில் வந்து ஏன் பாலிட்டிக்ஸ்க்கு வந்தேன். He used to be a wonderful lawyer because I have seen his trial papers. Cross-examination, I always tell him. So, there are things which what is visible to the eyes of the prosecuting agency or the investigating agency would be 7%. But அவர் சொல்லுவார், இங்கே ஒரு 7 பேர் இருப்பான், இங்கே ஒரு 7 பேர் இருப்பான், இங்கே 4 பேர் வாட்ச் பண்ணுவான். ஆக்சுவல் அசரன்ஸுக்கு வந்து 6 பேர் இருப்பாங்க. ஃபேக் சரண்டர் ஒரு 10 பேர் இருப்பாங்க. ஸோ ஒரு பெரிய மாடல் ஒன்று சிட்டியில் நடக்குதுன்னா not less than 30 to 40 people are there in that act. That is the organized structuring. அவர் வந்து பக்கத்தில் வந்து பார்த்த மாதிரியே சொல்லுவார், நாங்கள் சிரிப்போம், சார் இப்படிதான்டா அப்படின்றாரு. ஸோ தட் இஸ் தி எக்ஸ்பீரியன்ஸ். ஒரு ட்ரையல் எப்படி நடத்தணும்னு அதோட உட்காந்து கேட்கணும். எதை முதல்ல சொல்கிறது எதை கேட்கக்கூடாது, எதை கேட்கணும், அப்படி தான் ஒரு ட்ரையல் எடுத்துகிட்டு போகிறது. நான் மட்டும் முதல்ல உட்காந்து கேட்குறது, சார் எதை கேட்கக்கூடாது சார், ஏன்டா கேட்டேன்னு போகிறோம். ஸோ ட்ரையலில் when you ask a question, you are not supposed to get a single negative answer. Recently, I was doing a record trial before the election. Prosecutor chief விட்டார். Cross examination மட்டுமே படிச்சிருந்தார். நான் அதெல்லாம் மட்டும் படிக்காதீங்க, சீஃபை படிக்கனா சீஃப் எல்லாம் நீங்கள் தான் கிளாஸில் வாங்கி கிளாஸ் வாங்கி எடுத்துருக்கீங்க. ஸோ வி ஹேவ் டு அந்த இதை நம்ம பண்ணியே ஆகும். எல்லாரும் இந்தியாவில் வளர்த்த தப்பு. நோபடி இஸ் அ பர்ஃபெக்ட் லாயர். நம்மளே இப்போ கிளாஸ் முடிச்சுனாலே முதல் யோசிச்சு வேண்டாம் தான் போய் அந்த கேள்வி கேட்கல. ஸோ தீஸ் ஆர் திங்ஸ் வி ஹேவ் டு செல்ஃப் introspect ourselves to see that whether you are doing justice. Okay, that apart. Now here, this incorporates certain interesting offences like selling of public question papers. In the selling of question papers under which provision or under which definition this can be brought under the IPC letter. I may be wrong. ஏன்னா ஒரு கொஸ்டின் பேப்பர் எடுக்கிறோம், அது ஜெராக்ஸ் போடுறோம், கொடுத்துறோம். தெஃப்டில் பண்ணலாமா? தெஃப்ட் ஆஃப் வாட்னு ஒரு கேள்வி. இட் வாஸ் ஜஸ்ட் பிகாஸ் ப்ரூஃப். அப்போ மேக்கிங் தட் an independent offense like snatching. Now theft includes trick theft. நைஸாக பேசி இப்போ ரீசெண்டாக நடக்குதுன்னா அம்மா நல்லா அடிச்சு சண்டை போட்டு வராங்க, செயின்லாம் எடுத்து உள்ள வச்சுருவோம். இதெல்லாம் நியூஸில் பார்க்குறதா ஒரு பொட்டலம் கட்டி கையில் கொடுத்துட்டு அவங்க போனது பொட்டலத்துக்கு மண்ணு தான். இட்ஸ் ட்ரிக். மண்ணை மட்டும் வச்சுட்டு அவன் செயின் அடிச்சுட்டு போயிட்டே இருப்பான். தட் லேடி அந்த உமன் would be under the belief that நம்மளை பத்திரமா கையில் கட்டிட்டு 10 அடி போய் அவன் திறந்து பார்ப்போம், உள்ள மண்ணு தான் இருக்கும், by the time you தான் இருக்கும். That would fall within trick theft. Hard work theft. இன்ட்ரெஸ்டிங்காக பார்த்தீங்கன்னா ஒரு ஊர் மார்க்கெட் யூஸ் டு பி. I used to buy books when I was doing my college. அந்த புக்கு வந்து படிக்கிறதுக்குலாம் இல்லை, ரொம்ப அழகாக இருக்கும். அந்த எஸ்தெட்டிக் வேல்யூ வந்து அழகாக இருக்கும். அந்த லெதர் எம்போஸ் பண்ணி கோல்டில் வந்து போட்டு பண்ணிட்டு இருப்போம். நான் சொல்கிறது 20 வருஷத்துக்கு முன்னாடி அந்த புக் வந்து ஒரு காஸ்ட் 130 pounds. பட் பஸார் மூர் மார்க்கெட்டில் வாங்கினது வந்து 50 ரூபா 55 ரூபாய்க்கு ஆகும். எப்படி அவனால் விற்க முடிஞ்சதுன்னு பார்த்தா, as consignments travels throughout the world. ஆக்ஸ்போர்ட் வந்து பிரிண்ட் பண்ணி டிஸ்ட்ரிபியூஷனுக்காக போகும். when the ship is docked in Chennai port, கார்கோவில் வந்து எடுத்துருவாங்க, புக்கு எடுத்துருவாங்க. they do not know the value of them. பார்க்கறதுக்கு அழகாக இருக்கும், அவ்வளோ. அந்த புக் எடுத்து வந்து விற்க ஆரம்பிப்பாங்க 50 ரூபா 100 ரூபாய்க்கு. தட் இஸ் கார்கோ தேஃப்ட். டிஷர்ட்ஸ், மொபைல் ஃபோன்ஸ், எதுவானாலும் இப்போல்லாம் ரேம்பட்டாக நடக்கிறதா. ஒரு கன்சைன்மெண்ட் வருதுன்னா உள்ளே போய் பார்த்து திருட்டு போயிடுவாங்க. ஸோ தட் இஸ் நவ் அட்ரஸ்ட் அண்டர் செக்ஷன் 112 எக்ஸ்பிளனேஷன். நவ் பிக் பாக்கெட்டிங் இஸ் அகேன். பஸ்ஸில் ஒரு பிக் பாக்கெட் அடிக்கிறாங்கன்னா 5 பேர் இருப்பானுங்க பஸ்ஸில். எண்டில் அடித்தாங்கன்னா ஃப்ரண்ட்டில் இருக்கிறவங்கிட்ட போய் அவன் இறங்கி போயிட்டே இருப்பான். பை த டைம் he realizes the contraband would have left the bus. அவன் போய் நடந்து போயிட்டே இருப்பான். 5 பேர் அமைதியாக இருப்பான். பிடிச்சாலும் எங்கிட்ட கடாதுன்னு கேட்பான். Now that is brought under section 112 as petty organized crime. And shoplifting. அந்த காலத்துலேருந்து இருக்கும். அது ஷாப்லிஃப்டிங் போது கதைகள் வரும். வேணாம், அது எப்போ சொல்கிறேன். theft of automated teller machine. இப்போ எல்லாத்துலேயும் ஏடிஎம்ல வந்து இது பண்ணுறது. These are all new age offences which are now incorporated in the new Nyaya Samhita and it's been addressed. 112, 113, அதாவது 111, 112, 113 லைனாக வருது. Terrorist Act. So whoever does any act with an intent to threaten or likely to threaten the unity, integrity, sovereignty, security and economic security of India, or with the intent to strike terror or likely to strike terror in the people or any section of the people in India or in any foreign country by using bombs, dynamite, explosives, inflammable substances, firearms or other lethal weapons, poisonous, noxious gases, chemicals or by any other substance, whether biological, radioactive, nuclear or otherwise, of hazardous nature or by any other means whatever nature likely to cause death or injury to any person or persons, loss or damage to destruction of property, disruption of any supplies or essential services essential to the life of the community in India or any foreign country, damage to the monetary stability of India by way of production of smuggling, circulation of counterfeit Indian paper currency, coin and illegal material, damage or destruction of any property in India or in any foreign country used or intended to be used for the defense of India in connection with any other purposes of government, India, state of government, area agencies. This is an exhaustive one. Okay. It says 7 subsections. As we have seen in section 111, this is also self-contained. Oh, interestingly, foreign country label. That gives, there is an explanation that's been given. Subsection A, clause 5 there is a damage or destruction of any property in India or any foreign country used or intended to be used for the defense of India or in any connection with any other purpose of the government of India or any state government or any other agencies. So foreign country embassy attacks. So even the embassy attacks can be brought and tried. In embassy attack, suppose it's a floating island theory. Any embassy in that country means that itself is a sovereign land of that particular country in which the flag is, which the nation which flag it bears. So embassy so this is again this is another of the new terrorist act. It's become a very common thing. So 113 terrorist act, it has to be considered. And last of the provisions of the Nyaya Sanhita, which I think is very interesting, would be 152. Now sedition is taken out. Sedition they have brought in this interesting provision of 152. An act endangering sovereignty, unity and integrity of India, whoever purposely or knowingly by words, either spoken or written, or by signs, or by visible representation, or by electronic communication, or by use of financial means or otherwise, excites or attempts to excite secession or armed rebellion or subversive activities, or encourages feelings of separatist activities, endangers sovereignty or unity or integrity of India, indulgence in or commits any such action, punished with imprisonment for life, with imprisonment which may extend to 7 years, shall also be liable to fine. There is an explanation. Comments expressing disapprobation of the measures or administrative or action of the government with a view to obtain their alteration by lawful means without exciting, attempting to excite activities referred to in this section do not constitute trouble. So, fair criticism is permissible under section 152. Now, what is the danger? In what way is going to be beneficial? If you have the habit of watching YouTube, day in and day out, there is hate speech which has gone beyond the tolerable limits. கெட்ட வார்த்தைகள் வர ஆரம்பிக்குது சகஜமாக. அதை காமெடியாக பார்க்குறாங்க. நேற்றெல்லாம் ஒரு ப்ரோக்ராம் பார்த்தேன், 2.5 hours ஆல்மோஸ்ட் ஒரு 1.1 million views, 2.5 hours over. It was nothing but rubbish. It was one community spewing hatred against another community. 1.1 million views in a matter of few hours. That means the mindset of the people has become pervert. இதை என்ஜாய் பண்ண ஆரம்பிக்கிறாங்க, people ரசிக்கிறாங்க. அன்ஃபார்ச்சுனேட்லி என்னுடைய லெக்சர் ஒன்று இருக்குது, இப்போ தான் 1500 ரொம்ப போயிட்டு இருக்கேன். அது அந்த அளவுக்கு போரிங்காக இருக்குன்றதை நான் ஃபீல் பண்ணுறேன். பிகாஸ் இட் இஸ் நாட் இன்ட்ரெஸ்டிங், பட் இட் இஸ் அ மேட்டர் ஆஃப் இன்ட்ரெஸ்ட் மாதிரி ஆகிடுச்சு. ஒருத்தங்க இந்த பக்கம் ஒரு லிஸ்ட் ஆஃப் யூடியூப் சேனல்ஸ், இந்த பக்கம் ஒரு லிஸ்ட் ஆஃப் யூடியூப் சேனல்ஸ், ரெண்டு பேரும் மாற்றி ஜஸ்ட் ட்ரேட் hatred. And people are enjoying it. That is the order of the day. So this will curb such activities because it says purposely or knowingly by words, ஒரு arm, or by electronic communication, other arm, excites or attempts to excite secession or armed rebellion கிடையாது, subversive activities கிடையாது, encourages feeling of separatist activities, polarization, material of which religion you belong to,